Hi, I'm Shan Wu with a Under Color of Law hot take on the confirmation hearings that started at the Senate Judiciary Committee for several top DOJ officials. One of those Justice Department officials is going to be John Sauer, who is one of Trump's personal attorneys, another one of them who is up to be at an important position in DOJ. And his confirmation was particularly notable. I just want to go over a couple of things. First, the position he's up for is called the Solicitor General of the United States. And that is a position so powerful that it has sometimes been referred to as the 10th justice, meaning it's an additional Supreme Court justice. That is the lawyer at DOJ who is responsible for arguing and deciding to bring any cases before the United States Supreme Court in which the United States is a party to that case. There are a number of assistants to him. It's not as though he will personally argue every single case. But in addition to the litigation before SCOTUS, they also heavily weigh in as to what will be appealed in the lower courts, because the Justice Department has a process where if there's a case that went adversely to them, whether civil or criminal, they first have to decide whether they want to appeal the case. They take into consideration factors such as, if we appeal this case, are we in danger of making bad law? Meaning, is it better just to let this adverse decision sit maybe in the trial court, not make precedent over it? Because this is an important basic thing to understand. A trial court's decision isn't really binding on anyone except the parties before the trial court. Now, a district court judge, a federal one, can make a nationwide injunction that's binding on everyone. That's going to get appealed and questioned. But a decision like, yes, I'm going to dismiss this case, I'm going to suppress this evidence, I'm going to rule this way on an evidence piece in a civil case, that isn't any kind of precedent binding the way when you go to a appellate court and they write like a more in-depth legal opinion, that's considered binding for that whole area of the country, that circuit that's going to be binding upon. And then if it goes to the U.S. Supreme Court and they issue an opinion, obviously that becomes like the quote law of the land. So DOJ considers whether to even appeal anything, because you don't want to run the risk of, okay, we think this judge was way out there in left field, but what we don't want is to take it to the appellate court and then they happen to agree with them and now we're kind of stuck with more of a rule. They prefer just to let the bad decision sit there as an outlier. That's one of the ways in which the Solicitor General's position, known as the SG, is such an important position. Now, John Sauer's up for it. He was Trump's personal attorney. And what he is particularly notable for was his argument on the presidential immunity case, where he argued before the Supreme Court. And as you may recall, the court made up out of whole cloth this notion that there is a presidential immunity. They came out with a very complex system for determining whether there's a core presidential power, is it at the outer limits of the core presidential power, et cetera, et cetera. But the real effect of that for Trump was a great help, right? Because they said that many of his actions would be protected while he was president. His lawyers then went to town with that, arguing that all the cases against him needed to be dismissed because it fell under that. It didn't. But once he became the president-elect again, you notice DOJ was like, oh, given that decision, we're going to dump these cases at this time. I mean, they could have waited another 4 years, maybe, but that was an immediate outgrowth of that really poor decision. Well, notably, during that case, John Sauer was asked a very famous hypothetical at the D.C. Circuit Court of Appeals. That was the intermediate appellate court that heard the presidential immunity case. Now, the judge who asked him that question was Florence Pan, who, full disclosure, her parents were friends of my parents. She's a really brilliant jurist. And she asked this great question. It's really hypothetical for the ages. Appellate judges like to ask hypotheticals. They use particular examples to try and flesh out the full significance of an argument. So here was Sauer arguing that you cannot criminally prosecute a president unless they had first been impeached and then convicted by the Senate. So we'll take a listen here to Judge Pan's famous question. Okay, that is the famous hypothetical about SEAL Team 6, where she asks Sauer, is it your position that if the president ordered SEAL Team 6 to assassinate a political rival, nothing can be done except you got to first impeach him and then convict him? That same point came up during his confirmation hearing today. And we can play a little bit of that.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes.
And you see that Sauer leans into that same position again, saying that it's the situation where the president would be impeached and convicted. He seems to say, oh, that's going to happen, for sure in an outlandish case like this. But we've seen that's not so clear that any outlandish situation would actually cause Trump in particular to be impeached and then actually convicted by the Senate. But Sauer is leaning into that point, and he's asked a couple of hypothetical questions there, and he actually mentions two cases. His basic answer is, look, this is all hypothetical. Donald Trump is not going to have me do anything outlandish, but there could be extreme situations, he says, where you might have to disobey the court order. And he mentions two cases, Korematsu and Dred Scott. So Dred Scott was the famous sort of upholding slavery decision that's widely thought of as a disgraceful Supreme Court decision. And also Korematsu, which was the Supreme Court decision, also disgraceful, saying that it was fine to intern American citizens who were of Japanese ancestry during World War II. So both of those cases eventually were shown up to be terrible cases. And in the Korematsu case, there were reparations. Dred Scott's widely cited as an example of institutionalized racism. And so Sauer thinks he's making this good point of, wow, these two cases are like really out there. Everyone agrees they're terrible and, maybe they shouldn't have been followed. And when he's pressed on that point, he's really got a problem, right? This is the guy who's the brilliant legal lawyer who's going to represent the United States before the Supreme Court. And he's asked the question, isn't it true, though, that in Korematsu and Dred Scott, they were both good law for many, many years. They were followed, even though in hindsight, they seemed to be obviously bad racist decisions. To which all Sauer could respond was, maybe a lot of historians, think it would have been better not to have followed that. Great. Historians, though, don't run the country. They're judging things from the vantage point of history. And the important takeaway there, though, is even though people now think those are terrible decisions, even though at the time a lot of people may have thought they were terrible decisions, they were followed. Nobody stood up. The president didn't stand up and say, I'm not following this. Do with me what you will, Supreme Court. Good luck. That is a problem that this man will be the next Solicitor General. And let's talk about what he's really saying, right? Let's deconstruct that. What he's really saying is the executive has the most power. And you will hear the usual outcry about that would be a constitutional crisis. Congress has the power of the purse. The courts have the power of judging constitutional issues. If these three branches have a point where they're not agreeing with each other, you have a constitutional crisis. And my take on that is, that's like a fictitious thing, constitutional crisis, because it's still working. If they clash in the courts and the court decides, it's still working. As I wrote in the Daily Beast, and I'll remind you that and put this image up, if the executive actually says, I'm not following what you're going to do, make me, that's not a constitutional crisis. That's the end of the government. Okay? The executive's taken it over. It's a dictatorship. Why? Because the real point there is, as Chairman Mao once said, all power flows from the barrel of a gun. Who controls the gun? The executive, right? He's the commander in chief. He's got the guns. He's got the army here. Side note, ultra-right conservatives are always talking about that, right? We got to arm ourselves to guard against, the government having the guns. So we got to have guns. Well, here's a situation that he's really talking about where the executive wins because the executive has the guns, all right? That's not a separation of powers question. Separation of powers is how this all balances with each other because all three branches are working together for good government. It's not a question of who wins in the fight. That's a no-brainer. Who wins in the fight is the person with the gun, and the executive has the gun. That's what Sauer is really talking about. That's what's behind that, and that's what we in media, we as citizens really need to call out what they're really talking about. So we'll keep an eye on that. Unfortunately, I think he probably will be confirmed, but we'll keep calling these things out, and we'll talk to you soon. Thanks again for all the replies and comments. They're really helpful, and we'll be talking to you again soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.